Hello, everyone. Welcome back to the LAOT podcast. I'm Arnav Mathur, and today we are going to talk about a law that was designed to stop politicians from jumping ship and whether 40 years on it is still doing that job or whether it's become the very vehicle through which they cross the floor. For context, here's what has happened so far. On April 24th, 7 of Aam Aadmi Party's 10 Rajya Sabha members of parliament joined the Bharatiya Janata Party. On April 27th, the Rajya Sabha chairman C.P. Radhakrishnan treated it as a merger and not a defection. Aam Aadmi Party's strength in the House fell from 10 to 3, and one of the 3 remaining members, Sanjay Singh, filed a disqualification petition on the very same day. Now, the 7 members of parliament rely on paragraph 4 of the 10th schedule, which ostensibly exempts a merger of at least 2/3 of a legislature party split. 7 out of 10 clears that threshold, and therefore their argument is that this is a valid split and not a defection. But can there really be a merger when only the legislators switch sides while the parties themselves remain separate? Is this a valid constitutional merger or, as Aam Aadmi Party says, constitutional fraud? We have seen similar disputes before as well in Goa, Telangana, and most dramatically in Maharashtra in 2022. Therefore, the bigger question for today's episode is whether anti-defection law still prevents defection or is the tool for them. To help us think through all of this, we are joined by Professor Tarun Khaitan. Professor Khaitan,
Thank you for having me.
Professor Khaitan is the chair of public law at London School of Economics and an honorary professorial fellow at the Melbourne Law School. Previously, he was professor of public law and legal theory at Oxford and continues to be a visiting professor at Chicago, Harvard, and NYU. He completed his undergraduate studies at NLS Bangalore and then went to Oxford for his postgraduate studies as a Rhodes Scholar. Professor Khaitan, thank you so much for joining us today. Professor Khaitan, let me start by asking you to explain what the 10th schedule actually says. What is the context for the 10th schedule? How is it structured? What is the sort of conception of a political party that this schedule embodies?
Okay, so I think I need to start well before the 10th schedule, and in fact, well before the Indian Constitution, because thinking about political parties and constitutions does not come naturally to the Anglo-American tradition of constitutionalism, right? And this allergy to thinking of parties and constitutions goes way back to the American Constitution, because the American founders were famously hostile to political parties. Now, remember, this is a time when democracy has not really taken roots in America or anywhere, and therefore they did not really understand how indispensable parties are for electoral representative politics in any reasonably large state. So, and they also thought of parties as what they called factions and so on, but we don't need to go into that, right? Now, given the outsized influence of the US Constitution in the entire English-speaking world and beyond, parties are conspicuous by their absence in our constitutional thought. And therefore, the 1950s Constitution, for example, following the Anglo-American tradition in this regard, also did not have much to say about parties, right? So the 10th schedule is introduced into the Constitution through an amendment in the 1980s to fix a real problem that has emerged in India by then, right? What is the problem? The problem is that legislators elected on a party's ticket jump ship and join another party. Now, any robust, resilient, healthy democracy can deal with occasional what we call defection from one party to another. But when this defection becomes all too frequent,
Yeah.
becomes quite large in scale, and most importantly, when there are good reasons to believe that the defections are not happening for uh, ideological or reasons or for policy differences. So,
Mm.
it's quite possible that I might decide I no longer agree with my party's policy position on certain issue and I might defect for that reason. Right? But when there are good reasons to believe, as was the case in India, that something else is um, is the driver behind these defections, then you need to worry. Now, in the Indian context, the drivers primarily have been a powerful party luring legislators of a weaker party.
Yeah.
Powerful can be in terms of financial power.
Yeah.
So we know there have been many cases where a financially powerful party has basically bribed
Yeah.
opposition legislators to jump ship. Or it could be the lure of office, right? We know that in clientelist politics like India, when a party comes to power, it can distribute largesse, including ministerial positions, including lots of other stuff, right? So when those become the motivators, then two things happen. The first is that the system, politics becomes corrupt. I mean,
Yeah.
there is corruption in politics for other reasons as well, mainly electoral
Smack.
spending,
Yeah.
and electoral spending thresholds legally are very low. We all know that elections cost more than that, so you have to
Yeah.
use unaccounted money. But this becomes another cause of political corruption. And the second, perhaps even more damaging reason for democracy is that it becomes a tool for the ruling party, a weapon for the ruling party or a
Mm.
powerful party to suppress and delegitimize and eviscerate the
Yeah.
political opposition. So, for all those reasons, I think we framed the anti-defection law.
Yeah. So what I understand is that it's defection by itself is not the issue. It's the underlying reason for defection. And if it's ideological based, then it seems to be okay because then the legislator is switching because of purely ideological reasons for which they were elected. But then the moment you have power and money entering into the picture, then it becomes a real issue that needs to be curbed, and the 10th schedule was introduced for it. So,
Reason and scale. So I would just add
yeah,
scale to that as well, right? The frequency and scale also matters because there's also an estoppel of sorts, right?
yeah,
There is a sense that politics today. I mean, when you go to cast your vote, right? I mean, it's very hard to disentangle who your vote is for, whether it's for the party's leader, or your
correct.
legislator. But it's very clear. I don't
Mm,
think any political scientist will deny that in elections in India, at least a partial, a substantial, significant portion of the motivation for
mm,
how you cast your vote is not the party, right? So there's also a fairness, reciprocity, a fairness to the voter
mm,
and voters' expectations involved here as well, which is an additional reason which would count against party defections for whatever reasons
correct.
whatsoever. And we may not see it as a huge problem if the scale remains low, but if the scale
Yeah,
becomes high, then that becomes an additional reason to worry about defections in politics.
correct. So I understand what the problem was, but what does the 10th schedule actually say? What is it in terms of its structure and drafting? How is it? What is it actually trying to say?
Okay, so look, the main purpose of the 10th schedule um, is to say that if a legislator defects from her party,
Yeah.
then she will be disqualified. So she will have to vacate her seat, and effectively new elections will have to be held for that seat, right? So you go back to the people, and she's not barred from contesting again.
Yeah.
She
So
can
re-election is
contest
a
from her
possibility.
new party. Exactly, right? So she can go back to the voters, and this sort of follows the fairness and expectations of the voters point as well. That you go to the voter with your new party badge and say, look, do you still trust me, right?
Yeah.
That is the essential idea. Now, obviously, to make this workable, you
Mm.
need to do many things,
Mm.
right? You need to first decide um, what is the party or
Correct.
who is the party, right? A political party is not a monolith.
Mm.
There is the party leader, sort of the president or chairperson or whatever, according to the party's constitution.
Yeah.
Some parties have collective leadership, like the Politburo
Mm.
in communist parties. Then there's the party organization. There is
Mm.
the party's legislative part, the legislative party in various houses, so the Lok Sabha legislative party,
Yeah.
Rajya Sabha legislative party, state assembly legislative party. There is a party internal administrative organizational structure,
Correct.
right? Various party officers, the secretary general, the treasurer. There's a party member, there's a
Mm.
party affiliate, there's a party donor, right? So the party is not a a structurally hyper formalized organization that
Mm.
speaks for external purposes with a single voice,
Yeah.
right?
So very
The
flexible.
party is many things, exactly, right? And that flexibility and that informality is necessary for the party to do what it needs to do. If the law imposes a very formalized structure on the party, then it will not be able to perform this in between role
Mm.
between state institutions and the people, right? So state institutions, for example, speak in one voice, at
Mm.
least normally speaking, they're obliged to speak in one voice. So there's very clear lines of who gets to speak for a government department or a ministry that the petty bureaucrat may not speak. It's a right. Party is just different from a state institution, right?
Yeah.
It is quite rightly formalized to a lower degree, and that creates a difficulty in terms of what is the party,
Mm.
and then given the factual difficulty around that question, the
Yeah.
question of when has a defection taken place
Mm.
also becomes complicated, right? Because what counts as defection? You don't formally resign from your party's ticket, but
Mm.
you publicly criticize the party, you attend meetings of the other party, you attend press conferences from the rival party, uh, or uh, you vote against the party or you campaign against the party. So there are many ways of defecting from the party, again,
Mm.
which are not and cannot be fully formalized.
Correct.
So because so take an example of marriage, right? So law has
Mm.
to also deal with the question of when has a marriage taken place, right?
Yeah.
Now the law might take the view that um, there are certain types of formalities. There's a set of formalities, and this is all we will recognize as a valid marriage. So in Hindu marriage, it's saptapadi or so on,
Mm.
right? But then there may be some communities where marriage is less formalized, right? The ceremony
Mm.
of marriage is not salient when people start living together, etc. So then there's a dilemma for the law: should it recognize this informal arrangement as marriage, for example?
Yeah.
So the similar type of legal dilemma, right? Now, law can either force parties to
Mm.
become more formal organizations,
Yeah.
right? But then something will be lost. Then parties will become more like state institutions and they will lose the very flexibility that allows them to do political work, to connect the people with the state, right? So that's rightly not the path taken in India to
Mm.
force parties to formalize. But the consequence of that is
Mm.
that what is the party or who speaks for the party and
Mm.
what is a defection?
Mm.
These are both questions of fact.
Okay.
They are not questions whose answers are necessarily self-evident. They will be self-evident in some cases,
Yeah.
right? So I formally write a letter to the president of the party and say I hereby resign, etc. That is clearly so,
Yeah.
right? But it will not necessarily be self-evident. And because of the stakes in the game, because of all the lure of office and the desire not
Mm.
to lose your seat and maybe money changing hands and so on, uh, there are good incentives for people to use to defect informally, right, or
Mm.
to game the system to try not to be caught,
Yeah.
right? So it's precisely the kind of problem where you have where the law is forced to acknowledge informal mechanisms, but
Mm.
but there are huge incentives
Mm.
on the part of the wrongdoer in law's eyes here to
Yeah.
exploit that informality to not be caught. And that is the problem with the 10 schedule, right? So it's not clear
Mm.
what the party is or who speaks for the party. It's not clear what a defection is. And
Mm.
then for reasons of uh, fairness, or what they thought would be fair, is when drafting the 10 schedule, in order uh, to reduce its perhaps overarching character,
Yeah.
they
To
carved out
reduce its
two
bite
exceptions.
that it
Exactly. They carved out two exceptions. They say, look, I mean, okay, so, if you legislators leaving a party, that is defection. But, what if a party splits?
Mm.
Or what if an entire party merges into another party, right? And these things are not unknown in India. So they carved out exceptions for that. So
Mm.
they said, okay, when there's a split, that does not count as a defection, but will define the split as a one-third threshold of the party moving
Yeah.
away. And a merger is when the entire party joins in the party. Now, again, as soon as you introduce these two reasons, for good reasons, for reasons of fairness, right?
Yeah.
When they're introduced into the matrix, then you have two more evidentiary problems,
It
right?
shows that,
What is a split and
yeah.
what is a merger? So these are also not clear-cut
Mm.
phenomena, and therefore you have a variable matrix of at least four different concepts: party, defection, split, and merger,
Merge. Mm.
and each of them can be gamed. So
Yeah.
that is the problem with anti-defection law, and this is a
Mm.
problem in the mischief itself that the law is trying to fix.
Yeah. I think the four variables that you talk about are really important because, like you said, each of these variables has multiple variables within it as well, and there's always a possibility of how these are to be interpreted. And one such variable that's now come into the limelight because of the Aam Aadmi Party case is the provision of merger, the merger exception. I will read out paragraph 4 of the 10th schedule
Hmm.
for some context and to lay down the standard of what we're talking about. So, paragraph 4 is titled Disqualification on Ground of Defection, Not to Apply in Case of Merger. Subparagraph 1. A member of a house shall not be disqualified under subparagraph 1 of paragraph 2, where his original political party merges with another political party and he claims that he and any other member of his original political party have A, have become members of such other political party, or as the case may be, of a new political party formed by such merger, or B, have not accepted the merger and opted to function as a separate group from time to time of such merger. Such other political party or new political party or group, as the case may be, shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of paragraph 2 and to be his original political party for the purposes of subparagraph. Now, subparagraph 2 is the core of this paragraph, which states, for the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of a house shall be deemed to have taken place if and only if not less than two-thirds of the members of the legislature party concerned have agreed to such a merger. Now, it reads very complicatedly. It's got paragraph multiple times written. But essentially, from what I understand, there are two broad readings that you could take. The one reading is that the two-thirds threshold and the merger of the original political party are conditions that must be satisfied conjunctively. So both of them have to be satisfied. And the other reading is more disjunctive, where the moment you have two-thirds threshold being crossed, that's enough for the merger exception to apply. What do you think is the correct reading for this provision, specifically for the merger exception?
Yeah, well, first, I hope that, when you put this up, you will have the text for
Yeah.
viewers to see, because it's, as you say, a very complicated provision, and perhaps some unfortunate drafting. Right, when you try to cover all your bases as you would want to as a legislator, you often
Yeah.
create more problems too. So anyway, so the subclause 1 basically lays down the rule that when there's a merger, what needs to happen is that the original political party, and this is a term of art, this is
Yeah.
defined in the first paragraph of the 10th schedule, right?
Hmm.
So the original political party has merged with another political party.
Yeah.
Right? And what this paragraph is trying to do is to create a fairness rule for every individual legislator of the party, to give them a choice.
Yeah.
To say when. So let's take more concrete examples, because it might be more useful, right? So let's say that party X has decided to merge with party Y.
Okay.
Right? Now, paragraph 4, subclause 1 says that when party X merges with party Y, every legislator who belongs to party X has a choice. They can either become a legislator of party Y,
Okay.
and their membership shall not be affected because this is a merger of two parties. Or they can say that I don't accept this merger. Right? Although party X has decided to merge, I am a dissenter. I don't accept this merger. I ran on party X ticket, and I'm faithful to party X. Right? For fairness reasons, the Anti-Defection Law says this legislator of party X, this sort of intransigent legislator who's refusing to merge, shall also not lose her party seat, her legislative seat. Okay, which is a fair rule, because if everybody else is leaving, I am remaining faithful. Why should I lose my seat, right?
Correct.
Now, this creates a problem, and the problem it creates is what counts as a merger, right? And we already hinted at this. Now, there can be multiple scenarios.
Yeah.
There can be a scenario where the party outside of the legislative party has merged with another party. But all legislators say we remain faithful to the original party. Nothing will happen. Their seats remain as they are, right? Now, but there can be other permutations and combinations. The easiest case would be the party as such merges. So party as such, by party as such, I mean whoever is authorized to speak for the party under the party's constitution. Let's call that person the president of party X, right? So suppose X's constitution says that for all external purposes, the party's position, the party's official voice shall be its president.
Okay.
So the president of party X is not a member of this house. Right? So is not a legislator. But the president of party X outside of the house says, we are merging with party Y. Right? Now, because paragraph 4 creates these choices for the legislators of party X, it allows the legislators of party X to either join party Y and keep their seat, or remain with party X and keep their seat. It needs to decide what counts as a merger.
Yeah.
Beyond what the president of party X has said.
Yeah.
Right? So basically, the constitution in the 10th schedule has two distinct actors for the party.
Yeah.
It defines the original political party, and it defines the legislature party, right? Now, for the purposes of counting as a merger, subclause 2 of paragraph 4 says that 2/3 of the members of the legislature party need to agree with the merger of the original party for this to count as a merger, right? And obviously, because this is a provision mainly geared at determining what is a merger, not for abstract purposes, but for the purpose of determining the continuing validity of legislators, it is primarily concerned with the legislative part.
Yeah.
Right? Now, so the problem then arises, as in the came of Aam Aadmi Party's example, that the president of the party has not announced any merger.
Correct.
Right. In fact, not only not announced any merger, denied that there has been any merger.
anything
Right?
that they're saying
Exactly.
completely separate.
Exactly. But two-thirds of the members of the legislature party
Hmm.
have announced that they are merging with another party.
Hmm.
Okay, so the question, look, so there are two ways to resolve this problem now, because we have one clause,
Yeah.
the governing clause, the main clause in paragraph 4, subclause 1, which says
Hmm.
the original party needs to merge with another party. And
Yeah.
then there's an evidentiary subclause 2, which says the merger of the original party shall be deemed to have taken place if and only if not less than two-thirds of the members of the party concerned have agreed to such merger. Okay. Now, look, logically, the phrase "if and only if" means it connotes both a necessary and a sufficient condition,
Yes.
right? So, uh, if and only if usually means that this condition is both necessary for this event to happen and is sufficient for this to happen, right? However,
Hmm.
the phrase in subclause 2 is used not to determine what the merger is, but it's a deeming clause, right? And it is made subject to paragraph 1. I mean, it's for the purposes of subparagraph 1, which gives rise to the complication. If the clause had simply said merger means
Hmm.
the agreement of two-thirds of the legislature party, right?
Yeah.
We will not be having this debate, because then merger would just mean the two-thirds, right? But
Yeah.
because it's, and look, this is unfortunate drafting in part, right? Part of the problem is that the drafting is not exactly clear, because subparagraph 2 starts with "for the purposes of paragraph 1."
Hmm.
So I think the proper literal reading, in my opinion, is that subparagraph 1 is the trigger.
Yeah.
Right? Something needs to happen to trigger subparagraph 1.
Correct.
And that trigger is the merger of the original party, not the legislature party,
Hmm.
but the original party with another party.
Yeah.
And then subparagraph 2 kicks in. So it's a chronological point, right?
Hmm.
When subparagraph 2 starts with the phrase "for the purposes of subparagraph 1," then I think it's only right to read subparagraph 2 is kicking in only after subparagraph 1 has been triggered.
Yeah.
Subparagraph 1 is triggered when the original party merges with another party. Then subparagraph 2 kicks in, and its only purpose would be to determine whether the merger, the prima facie merger announced in subparagraph 1, is to be recognized as a merger for anti-defection purposes.
Hmm.
So if a merger in subparagraph 1 is disowned by the legislature party,
Yeah.
then subparagraph 2 will operate to have the effect that no such merger would have deemed to have been taken place for the purposes of anti-defection, right? This is the only reading, I think, which preserves the content and meaning of subparagraph 1.
Yeah.
Because
So,
sorry, go on.
yeah. So just to understand your point, you're saying that these two conditions are conjunctive and they're also chronological, that you have a, let's say, party X announcing it outside of the parliament that we are merging with party Y. And then you have two situations that can happen. The first situation is where two-thirds of the legislature party says that we agree with it. In that situation, if any of the legislator then move and jump ship to party Y, then that is not anti-defection, that is a valid exception. The second situation is where the outside the parliament the parties have merged. Inside the parliament they don't have two-thirds of legislature agreeing to it. In that situation, any party X representative legislator, if he moves ship, then that would be defection. Is that
Assuming that the number of legislators jumping ship are less than
less
two-thirds.
than two-thirds?
Yes. So that's exactly the import, right? So it's not
Yeah.
just conjunctive, it is that there's a sequence
Yeah.
to the logic of this paragraph. And I prefer this reading only, mainly because the disjunctive reading,
Hmm.
uh, in effect, has the effect of more or less deleting the first paragraph, right? Or at least the first part of the first subparagraph,
Yeah.
right? So it will the members who remain loyal to the original party will still be saved, but
Yeah.
this whole the main stem of the first subparagraph will be rendered meaningless if we give a disjunctive meaning, because there is no situation in which the main stem will have any effect. If we have a disjunctive meaning, then if the only thing that counts, if the two-thirds legislature party decision is both necessary and sufficient, then the main stem requiring the merger of the original party with another political party is rendered completely contentless, right?
Yeah.
And obviously, there's a rule of construction that we should not interpret constitutions or any statutory provision in a way that renders them without any content whatsoever. So I think that is the main reason, logically and literally, why this is the right reading. There are obviously purposive or moral reasons as well, normative reasons why this is the correct reading. The purpose of anti-defection laws is to reduce and curb defections, and obviously the chronological and sequential reading better realizes that constitutional purpose. The disjunctive reading, which is more permissive of defections, is also bad because it goes against the purpose of the 10th schedule.
Correct. Yeah, and the whole point of having the original political party merge before you check whether the legislature party is in consonance is so that you have more, I would think, accountability, more less chances of defection happening in those situations, right?
Yeah.
All right, understood. So now let's turn to the question of adjudicator. The 10th schedule vests the decision of disqualification with the Speaker of the House. Now, speakers on one hand have delayed decisions relating to anti-defection law sometimes for years, and sometimes even till the term of the entire House has expired. In this case, however, we see that the Rajya Sabha chairman moved with like unusual speed, and within 3 days, this merger was recognized. But the disqualification petition is still pending. Is there something wrong that you think exists with the speaker as adjudicator model? And is there something that maybe judicial review can fix?
Okay, so look, you have a problem which we know will frequently involve questions of fact.
Yeah.
Right. That itself requires a judicial rather than a political decision, right? Because questions of fact are usually your questions of policy we think are right for political judgment. Questions of fact and law are right for judicial determination. This involves questions of fact and questions of law, as we have just discussed, right?
Yeah.
So already a political judgment is unwise. Now, apart from that, the second biggest issue is that we know that speakers are not non-partisan players in parliamentary democracies. Speakers, with a few honorable exceptions, have functioned as partisan actors.
Yeah.
Right. So it's like putting the fox in charge of the hen house, right? And then you complain that the hens are dying. So of course this is expected, right? The speaker is woefully inapt as an institution, both for their lack of judicial expertise to decide questions of law and fact, and for their lack of independence in this case, right? So if anti-defection law is a tool to protect the political opposition, which I think that is what it is, then asking the speaker, who would typically belong to the ruling party, to make this decision is not going to serve that purpose. Now, you could have had a design feature where maybe the speaker and the deputy speaker, who must necessarily be from the opposition party, have to make a joint call within a certain time or whatever, right? I don't know, some design policies options are possible that can mitigate the independence problem, but again, that would create deadlock if the deputy speaker and the speaker disagree, and so on, right? Um, so Pakistan obviously learned. So they enacted their anti-defection law after India did it, and learned from the Indian example and what worked in India did not, and improved upon the design, mostly improved upon the design. And in the Pakistani anti-defection law, the declaration that there has been a defection is made by the party president.
Okay.
Right? But it has to be adjudicated within a specified time limit by the election commission.
Okay.
Okay.
So
Now,
it's just the party president plus the election commission, both of them have to do.
So the party president is a trigger because, if for example, I think of that as a standing question. Who can bring the claim, right?
Yeah.
I mean, if you ask the speaker to send the claim, then the speaker can sit on the claim without forwarding it, right? So basically, look, if you want a law to be enforced, give the power to bring the claim to the person who has the biggest interest in having the claim upheld, right? So it's just logical that the party president is that person. Election commission. So there can be good reasons to vest it in the election, in a judicial wing of the election commission, or an election tribunal. But we have to be careful about two things, right? We cannot replicate the problems that exist with the speaker's role. So, and there are three problems, right? One is gaming the timelines. Right. So there has to be a constitutionally mandated deadline, which, if not complied with, will have serious consequences like losing office. Right. The second thing is expertise. So the people, because this will involve questions of fact and questions of law, right? The body has to be adjudicative in nature, or at least quasi-judicial in nature. So you have to have some judicial expertise to respond. And the third is independence. Right. So our current design of the election commission, appointed by the prime minister and a minister and the leader of opposition, is clearly not independent structurally. Right. So you have to have an equal say in the design of whatever body. And I think my work on guarantors speaks about how this is important for election commission as well. The appointments of these bodies, these referees in politics, has to give equal voice, equal say to the government and the opposition. It cannot give an extra voice to the government. Right. So if these conditions are satisfied, and another thing has to be that any political gains of the defection, whether it is ministerial office, whether it is a new government, whether it's a collapse of the old government, all of this has to remain in limbo until the adjudicator has decided. Because part of the problem is that you game the system, you get the desired outcome. So even if you win in the court later, it's a very victory. Right? So any gains have to be stalled. And for a period, Pakistan also did not count the defectors' vote towards the determination of the matter in question. Right? So if you voted against your party, your vote counted as an abstention rather than as a negative vote against the motion or whatever. Right? That has been reversed by the Pakistani Supreme Court, and I think it's unfortunate that it's been reversed. But anyway, that's a different matter. But you can't allow people to benefit from a purported defection until the matter is judicially settled in a way that is credible by all parties.
Understood. But look, the reform conversation around 10 schedule has been as long as the schedule has existed. And barely anything has changed within the text except the split exception being deleted in 2003. And one explanation that I could think of was that, the parties that would have to legislate for an anti-defection law reform are the ones who benefit the most out of it, given the current system. If you have a whip that is backed by disqualification, it's giving you enormous discipline and power over your own party members. So, given this sort of an incentive structure that already exists, and you were talking about guarantor institutions and the ECI's change in how they're now being elected. Given this larger incentive structure, do you think it's even possible to have any reform within the anti-defection law?
Okay, so the first thing I would want to press you on is this, right? That um, the incentive structures are not uniform across parties.
Okay.
Right? It is anti-defection law is usually loved by the weaker parties. So there may be parties in opposition or financially weak parties or parties who are in power in the state but facing the might of an overweening central party. Right? The party that hates anti-defection law is the financially, politically powerful party.
Yeah.
Right? So don't assume uniform political incentives against anti-defection law. It's complicated, right? And as parties in a normal functioning democracy, if democracy is a system where parties lose elections, then it's in the rational self-interest of every party to accept anti-defection law, because they can all imagine themselves in the opposition at some point, right?
Yeah.
If a party has a plan for like being in power for 50 years and has no imagination of itself in the opposition, that's a different matter, right?
Yeah.
But in a functional democracy, it would be rational for you to accept anti-defection law. And don't forget that it is this very system that both created the 10th schedule. For all its flaws, the 10th schedule reduced defections. And also it is the same system that plugged in an important loophole by getting rid of the 1/3 split provision, right, which became a massive loophole in the system, right? So the evidence belies your claim that the system will not fix itself, right? Now there have to be many factors have to come together, right? And sometimes norms are very powerful. Male MPs have voted to accept women's reservation, knowing it might lead to their losing their seats. So sometimes the power of ideas need not be underestimated. The power of, with political, luck, right? So things have to fall in place. Civil society has to be clear-eyed about what kind of reform will benefit. You could easily imagine what is the current political opposition making a public commitment to amend the 10th schedule to make defections harder. And then when it comes to power, it will have to deliver on that promise, right? Or pay some political price for not delivering. So I would not completely rule it out. And also, obviously, we can also do some tweaks with the 10th schedule as it exists with good adjudication, right? So courts doing a purposive reading, so like this merger case, right? Courts have imposed, or at least try to impose, deadlines in other cases. So courts can do some things, mostly on the margins. They can't fundamentally change the character of the 10th schedule, but so that can happen even without a political
any political push.
Recalibration, indeed. Yeah. So I would not rule out the possibility of change.
Understood. That's very hopeful, and I hope some change happens. And I think the court's role can also be to look at how to disincentivize the gamification of 10 schedule, which you mentioned, just by setting deadlines, having a more purposive interpretation they can do. So I just want to ask one last thing about the philosophical core and the overall understanding of 10th schedule. I think it rests on a very particular and deeply contestable view of representative democracy. The basic premise is that if you are an elected representative, your primary loyalty is to the political party under whose banner you were elected. And it's contrary to what a Burkean trustee would be like. So it's like you mentioned about the bi-directional intermediaries, that the political parties aggregate citizen preferences and transmit the policy commitments downwards. So they act as intermediaries. Therefore, you need party discipline. So that's the understanding that exists. But what I feel that it's also done, it's created a parliament of silent delegates. There's no real freedom of speech within the parliament, and the legislators are so fearful of disqualification that there's no meaningful act of dissent that is often shown within the parliament itself. How do you see reconciliation of these two positions?
Okay, so first, I think the case for sort of the valiant, brave individual MP, fighting for truth and justice, is overstated.
Okay.
Um, um, so obviously, Madhav Khosla and Milan Vaishnav have a paper on democracy and defection where they basically make the argument that you're making, that anti-defection law silences MPs, takes away their freedom of expression. I think Udit Bhatia has similar ideas as well. And I think these are misguided ideas because first, they don't appreciate the reality of party politics in India, which is, and in particular global South context, which is driven by money and muscle power. We have a context where MLAs and MPs are, quite literally abducted,
Yes.
put in a bus, driven to unknown resorts, locked up for 3 days. And so this is, so to think about the problem from the lens of the global North, right, where these problems do not exist or do not exist nearly to the same degree, is to miss the point that democracy cannot survive uh, unless the political opposition lives to fight another day. And that the fundamental premise of anti-defection law, the fundamental point of anti-defection law, is to defend and protect the political opposition so that it can live to fight another day, right? And so I cannot emphasize enough how critical anti-defection laws are for the soul of democracy, right?
Yeah.
Now, that is not to say that the system cannot be fine-tuned and made better. So I mentioned the Pakistani amendment. Another regard in which the Pakistani anti-defection law was better than the Indian one was that it did not apply across the board, right? It only applied to a vote cast by the MP, by the legislator, on a matter of confidence, no confidence, money bill, or budget. Right. So basically, it was confined to questions or bills upon which the survival of the government depended. Right. But otherwise, MPs, the whips still existed, right? Whips exist even in the UK where there is no defection law. But otherwise, disobeying the party whip would just invite the normal party discipline, right? Of whatever party's internal disciplinary procedures, whatever. Right? So the constitutional big guns are brought out only for the really important matters. Notice how that solves another problem, right? It also solves, at least partially solves the problem of what counts as a defection. Because that is narrowly, clearly, and specifically defined as voting against the party on these grounds. Right? Now, that will still be a problem because we have legislators who belong to one party and work with another party.
Yeah.
But we will have to leave that to be sorted out by party discipline.
Yeah.
Right. And I think the constitutional. So that is one way in which you can confine the scope of anti-defection law. But I think the most important lesson to remember is that politics is not an individual sport. Politics is a team sport, right? And this insistence on customized, tailor-made, my MP, my ideas, my precise political views must be reflected by every politician, right? This is sort of the neoliberalization of politics,
Yeah.
right? Where political packaging, where compromise, consensus, platforms. I mean, solidarity requires compromise.
Yeah.
Coming together for collective action requires compromise, right? And just as it's not a problem for democracy that ministers are not free to openly criticize the government they are a part of.
Yeah.
It's not a look. And the final thing I'll say is this, right? That just because MPs are not allowed to speak against the party in the House in a plenary session, does not mean they have no avenues, right? Parties also have an internal life, right?
Yeah.
And some parties are more internally responsive than others,
Hmm.
but there are parties where legislators can raise matters internally. I am told, now we don't know, and I hope it remains that way, we never know, that the parliamentary committees
Hmm.
work very differently from the floor of the House, right? So one of the biggest mistakes I think we made was started broadcasting parliamentary proceedings
Yeah.
on television, and I think our adjudication is also going that way, right? But
Hmm.
it invites playing to the gallery, invites grandstanding, it invites, because that is what pays, right? Parliamentary committees that work behind closed doors, uh, the suggestion is that they work in far less partisan a manner. Now, of course,
Hmm.
under the current government, the role of and status of committees itself has gone down, right?
Yeah.
But that is a different
We've
problem
barely
to be
seen
solved.
any joint parliamentary committee for a long time.
Well, there are standing committees and
Yeah.
matters do go to them, but not enough and not as regularly and frequently. I mean,
Yeah.
committee work should be the rule, not the exception.
Hmm.
And, we were getting there. So that has to be restored. But anyway, all I'm saying is that A, the problem is overstated. There are other avenues. And B, that even within the current system, I think, we can narrow the scope of anti-defection law. It's an argument, perhaps, to narrow
Hmm.
its scope, but definitely not to give it up, because I think
Yeah.
that would be extremely damaging for whatever democracy we have left.
Makes sense. I think you've actually addressed all the points that relate to majority of the controversy. I think from the start, the laying down of the four variables and how they interact with each other really help. And I really like the point that you made about politics being a team sport, where you have to, even though you think that there's some particular ideology that needs to be represented within the parliament, the party discipline somehow helps in a compromised avenue and leads to a more uh, just a more democratic way of living and organizing political life. Thank you so much for coming to our podcast and explaining this really burning issue. And I hope to see you soon.
Thank you for having me, Arnav. It's been a pleasure talking to you.